hour's time, but I think what I can do is give people a general framework of the various bankruptcy terms and concepts so that you have a general understanding of the bankruptcy process, and either if you're trying to get involved into doing more bankruptcy work or if your practice sometimes comes into connection with bankruptcy, you'll know what to do and at least kind of have an idea of where to go or what is going on. Because a lot of times when people get involved with bankruptcy, if they're not familiar with it, it's very foreign to them, and sometimes people panic and say, okay, well, what's next? This has kind of thrown a wrench into everything that I've been doing, and what are my next steps? So the topics that we're going to cover today, and obviously I'll try and get into as many of them as we can. First, we'll go over an overview of the various bankruptcy chapters. Then we'll talk about some principles and key terms. We'll do a discussion on the key parties involved and the players in a typical bankruptcy case. We'll discuss the automatic stay, which is something that most people come in contact with if they do any type of litigation, or even if you just have a client that files bankruptcy and you want to know what you can and can't do. It's important to understand the automatic stay. We'll discuss the bankruptcy claims process, discharge, preferences and fraudulent transfers, which are litigation in bankruptcy, and the plan confirmation process. So first, I'm just going to talk about some of the various bankruptcy chapters, and then also give everybody an idea of the types of numbers of bankruptcy filings that occur, just so you can see how prevalent bankruptcy is. Although overall bankruptcy filings have been down the past few years, nationally in 2017, there were still a little bit under 800,000 bankruptcy filings. Of that, 97% of those filings were consumer filings, and obviously the remaining were primarily business filings that occurred. There were approximately 470,000 Chapter 7 filings, 1,092 Chapter 11s, and then for Chapter 13s, and this is for the individuals, there were about 300,000 that occurred. In Florida, in 2017, there were approximately 41,000 overall bankruptcy filings. That's the mix of business and consumer filings, with the largest percentage of those being Chapter 7. And in Florida, the courts are made up of the Northern District, the Middle District, and the Southern District. So the federal bankruptcy courts align with the district courts that we have in Florida. So when you hear people talk about a Chapter 7, what a Chapter 7 is it really is a liquidation of assets. So when someone files bankruptcy, if it's an individual, what they're saying is, other than my exempt property, I'm turning over everything to the bankruptcy process for it to be liquidated so that it can go to pay my creditors. And in turn, I'll get a bankruptcy discharge. On the other hand, there's a Chapter 13 process, which is typically called the wage earner reorganization, because you need to have income in order to file a Chapter 13. And what Chapter 13 is, it's a reorganization of an individual's debts. And typically there's a payoff and a bankruptcy plan that's in place for a period of 3 to 5 years. And at the end of that, that's when the filer, which we call a debtor in bankruptcy, will receive their discharge. Whereas in the Chapter 7, that process of the discharge comes a lot sooner because there is no plan or reorganization. And a Chapter 7 and Chapter 13 can be filed by individuals, whereas a Chapter 7 can also be filed by companies and business entities, whereas business entities can't file a Chapter 13. The next one that we have is a Chapter 11. And Chapter 11 is the typical reorganization. If an individual their debts and assets are too large for a Chapter 13, then typically they can file a Chapter 11. But primarily the filers for Chapter 11s are companies, and that's the typical reorganization process in which the company would like to continue going as a business, but they need to restructure and make changes to their relationships with their various creditors. There's also a couple other bankruptcy chapters that aren't as common, but they do occur at times. The first of those is a Chapter 12, which really deals with family farmers and family fishermen. We do see some of those in Florida, but I'll say that they're very rare that you will get a Chapter 12. The other one is the Chapter 9, and that's really a reorganization process for municipalities. When we talk about how rare they are, in 2017, nationwide, there were only 7 filed. So these types of bankruptcies are very rare. The peak of those filings occurred in 2012 when there were 20. So even in the peak year, there still aren't allowed a lot of reorganizations of municipalities. And this is the situation where some municipalities such as Detroit, San Bernardino, California, and Jefferson County, Alabama found themselves in, where they went through a plan in order to adjust their debts with all of their creditors. And there's certain requirements that they have to be met. And one of the things that when you look at the chapters for the bankruptcies, the reason why they're titled the way they are is because if you look at the bankruptcy code, which is the federal statute which governs bankruptcy, it's Chapter 7 within the code, and the code's Title 11, so USC Title 11. And the other chapter that we see a few of here in Florida as well, it's a Chapter 15, which really what that is, it's a foreign access to U.S. bankruptcy courts. So there's typically some type of insolvency proceeding that's pending in another foreign jurisdiction, and what they're doing is they're looking to try and get recognition of that in the United States for various reasons, whether there could be assets located here, there might be some claims that are here in the United States, and they seek the assistance of the United States bankruptcy courts to go through that process. In 2017, there were 86 filed nationally, and in 2016, there were 179. So when you look at the overall number of bankruptcies that are filed, this is really just a small fraction, but it's the United States adoption of the model law on cross-border insolvency, which was promulgated by the United Nations Commissions on International Trade. So this really is just to recognize foreign proceedings. And most people in their practice, even a lot of people who their practice is bankruptcy, will never come in contact or be involved in a Chapter 12, Chapter 9, or Chapter 15. The main chapters that people come in contact with are 7, 11, and 13. So in the bankruptcy process itself, there's definitely some key terms and principles that it's helpful to have an understanding of, just so you know the lingo when you're dealing with bankruptcy. One of them is the bankruptcy petition. Essentially, that's the application to the court advising that either the individual or the company is declaring bankruptcy. Really what the petition does is it initiates the entire bankruptcy process, and everything else flows from there. When you do file the petition, typically in connection with the petition or very shortly thereafter, you file a debtor will file a detail of their debts and liabilities, which is the bankruptcy schedules. So this is really just giving a really detail. It also will list certain claims of the debtor and certain transfers. And when I use the term debtor, I'm referring to the entity that filed the bankruptcy petition. And so that's what the bankruptcy schedules are. And the petition date is simply the date in which the bankruptcy case was filed. And that's important because when we discuss certain claims and deadlines, a lot of the claims and deadlines run from the petition date. So it's very important to understand the date in which the bankruptcy case was filed so as you don't blow certain deadlines within the bankruptcy case. The Section 341 meeting of creditors is a meeting that takes place normally within 60 to 90 days after the bankruptcy filing, and it's where the debtor appears and the creditors and other interested parties are given an opportunity to examine the debtor under oath. In an individual case, this meeting typically lasts 5 minutes or so. but in some of the corporate cases, it could be lengthier. It really depends on the facts of the specific corporate case. Proof of claim. So if anybody is involved or receives what's called a notice of bankruptcy and has a client that says, okay, what do I do with this? What's important from this? One of the things that you have to look for is the proof of claim. And this is important because you're not entitled to receive any distributions, and we'll get into the filing of a proof of claim a little later, but you can't receive a distribution unless you file a proof of claim. And the proof of claim outlines what the debt is that you believe the debtor owes. A discharge is essentially a permanent order that releases the debtor from personal liability for certain specified debts, meaning that there's no obligation to repay them once the discharge is entered. And in the individual case, this is typically entered. It could be 120 days after the petition date, or it could be lengthier depending on the facts. For corporate debtors, there is no discharge. The automatic stay is an injunction. It's the equivalent of an injunction that's entered, and it stays certain actions against the debtor. And essentially, its purpose is to give a breathing spell. And we'll get into some of the specifics of the automatic stay so that you can understand certain instances when it may apply and when it may not apply. A Rule 2004 examination is a bankruptcy deposition. So if you hear people talk about, it's a Rule 2004 examination, just think deposition. And the federal rules typically apply to the Rule 2004 examination. The bankruptcy estate is what's created upon the filing of the bankruptcy petition. And the bankruptcy estate consists of all the assets, claims, and liabilities that the debtor had prior to the filing. Typically, the bankruptcy estate does not consist of assets and liabilities that are either received or incurred after the filing of the bankruptcy case. And if we want to talk about a little bit about the key parties that are involved in the case, you have the debtor, and as we discussed, the debtor is the individual or company that actually filed the bankruptcy petition. You have a debtor in possession, which can only exist within bankruptcy, and after the petition is filed in Chapter 11 case, you have a debtor in possession, and really what that is a company that filed a bankruptcy petition and continues to operate within the bankruptcy process itself. So it stays in control of its operations, and it's dictates how the bankruptcy case will proceed. So that's what's the debtor in possession, and you'll sometimes hear that referred to as the DIP, D-I-P. A creditor is just an entity that is owed money by the debtor or just has any type of claim against the debtor. A trustee, typically a trustee is an individual that's appointed in a Chapter 7 case, and instead of there being a debtor in possession where the company is involved, there will be a trustee who is a fiduciary appointed by the United States Trustee's Office, who their goal and their duty is to manage and monitor the bankruptcy case, and they're the ones that will really investigate to see if any claims exist, and if there are, they'll make distributions to creditors, and if not, they'll close the bankruptcy case when that happens. But they're the ones that actually drive the bankruptcy process in the Chapter 7 context. You also have the United States Trustee's Office. They're essentially the bankruptcy watchdog. Their goal is to make sure that all the parties who are involved in the bankruptcy process are doing what they're supposed to do. You'll typically see them involved a lot more in Chapter 11 type cases. And their goal, like I said, is to just make sure that all the parties and the stakeholders are complying with the strictures of the bankruptcy code. And if not, on behalf of the government, they make objections and try and make sure and guarantee compliance. And then you also have the bankruptcy judge who's involved in the case. And then in the Chapter 11, sometimes you'll have a trustee appointed So typically that would happen in instances when the creditor body does not believe that the debtor in possession is complying with its duties and obligations under the bankruptcy code. And what they'll do is they'll attempt to have the court appoint a Chapter 7 trustee. The next step below having a full trustee appointed who would take over the operations of the debtor is an examiner. And what an examiner would do is they would come in and just examine to whether or not the debtor is complying or if there are certain things that occurred in which the debtor should not be a debtor in possession and a trustee should appoint it. But that's a third-party fiduciary who would report to the bankruptcy judge. Now, we briefly touched on it at the beginning, and we said one of the main topics that we'll talk about is the automatic stay. And this is where I see a lot of people get in trouble who don't practice bankruptcy. A lot of times it's people who do litigation, and they'll be in litigation. The defendant in the litigation will file bankruptcy, and they say, well, I have these depositions set. I'm going to go ahead and push forward to try and move these depositions. And, and if they don't respond, I'm going to move to get a default. And that's a bad idea because the automatic stay, which I put at the top, it's 11 United States Code Section 362. It goes into effect immediately upon the filing of a bankruptcy petition. There's no court order necessary, and it's an injunction that's in place. There are certain exceptions to the automatic stay, and if you see the outline, I list a few of them. But for the most part, it enjoins creditors from initiating a lawsuit or continuing to prosecute a lawsuit against the debtor, attempting to collect debts from the debtor, seizing the debtor's assets, foreclosing on the debtor's assets, perfecting a security interest in the debtor's assets, or attempting to set off any debt or that the debtor owes to you that arose prior to the bankruptcy case being filed. So it's very important to comply with the automatic stay. And what we'll talk about in a minute is what happens if you don't. But people say, well, how do I know? I mean, how do I know if someone filed bankruptcy, which would prevent me from continuing with litigation or sending a demand letter or anything else that's related to the collection of a debt or taking actions against a debtor? Well, in most situations, the debtor, or if they're the defendant or the plaintiff in a case, if they receive knowledge of it, you typically file a notice of bankruptcy, or if it's the debtor, they'll file a suggestion of bankruptcy in whatever pending litigation is happening. And the purpose of that is just to advise the court that a party has filed bankruptcy and the case should be stayed. So in most situations when that happens, that's great because it really does give people notice. It should list the bankruptcy case number so that you can verify it to make sure that there in fact was a bankruptcy case that was filed. But in certain situations that won't happen. No, the debtor won't file the suggestion of bankruptcy, and the other party to the lawsuit may not know about it. So sometimes parties do continue litigating because they have no knowledge of the bankruptcy case. But as soon as they do get knowledge, they're required to stop because the court can sanction people for violations of the automatic stay, because the purpose of the automatic stay is to give the debtor a breathing spell and allow them an opportunity to, if it's a Chapter 11 case, restructure. It also it'll let them take a step back to determine what issues are out there and try and come up with a plan to deal with those. In the Chapter 7 context, it's important because their goal there is to just discharge all of their debts. They don't want to continue, the debtor, with the with the litigation process or dealing with their debts or any claims that people have against them. So that essentially gives them that goal of stopping everything so that it can be dealt with in the bankruptcy forum. In certain situations, a party may seek relief from the automatic stay and essentially ask the bankruptcy court to lift the automatic stay. a lot of times where you'll see this come up is if it's a foreclosure process. So an individual will file bankruptcy and say, my foreclosure case is stayed, but sometimes they have no intention of keeping that property. So a lender will file a motion with the bankruptcy court seeking relief from the automatic stay so that they can continue with the foreclosure process and obtain a foreclosure on the property. What the bankruptcy court will not allow them to do is to proceed to get a money judgment against the debtor. It will solely, typically in that situation with a lender, will be to foreclose on the real property because if the debtor doesn't need the property or it's not going to be helpful to any type of reorganization process, if it is a reorganization, the court will allow them to proceed in state court with that foreclosure complaint. Sometimes people say, well, how do I know if it applies? There's multiple people involved in the case. Say there's several defendants, and only one of the defendants filed bankruptcy. Well, the automatic stay only applies to a debtor that files bankruptcy. So it's not applicable to co-defendants, co-obligors, guarantors, affiliates, principals, and property that's not part of the bankruptcy estate. There are certain situations in which people will still be a lot of times this happens with judges as well. They see bankruptcy and they say, okay, everything stops. Well, that's not the case. But what some people still need to do sometimes, because either the court requires it or that interested party is more comfortable doing it, is they will file a motion with the bankruptcy court, essentially asking the bankruptcy court for a comfort order, stating that the automatic stay doesn't apply as to the non-debtor parties. And a lot of times, although it's not necessary, people and judges like to do that so that they feel more comfortable in proceeding in the case, especially if a debtor is involved. One situation in which the automatic stay does not apply is if the debtor is a plaintiff and is seeking affirmative relief. A lot of times the debtor will stop proceeding with the case and try and get everything involved and into the bankruptcy, but there's no automatic stop to the debtor if they're a plaintiff or if they're seeking affirmative relief. There are certain exceptions to the automatic stay. So it's automatic except when it's not. And the exceptions are outlined in 11 U.S.C. Section 362B, but I'm going to go over a few of them that exist just so you can kind of have an idea of certain situations in which the automatic stay will not apply. And one of those, an important one, being criminal matters. So if a debtor is involved in some type of criminal proceeding or there's some type of investigation going on related to a debtor or an individual that filed bankruptcy, those matters are not stayed. The government entity is allowed to continue with those, prosecuting those, investigating those criminal matters, so the stay will not prevent those from occurring. Also, attempts to establish paternity, to establish or modify an order for a domestic support obligation, actions concerning child custody or visitation. These are all matters that are left to the family law court, and there's no need to involve the bankruptcy court. But like I said, there are certain situations in which it will arise where either the judge is not familiar with the bankruptcy process or the parties do want to just get that comfort order from the court, and they'll seek the comfort order for the stay relief anyway. To dissolve a marriage, so just because you file bankruptcy, the spouse is not prevented from proceeding to dissolve a marriage. But if in that process there is going to be some type of division of assets, then what happens is the automatic stay will apply to that aspect of it. So a lot of times this does delay some of those proceedings, especially when the issue is related to distribution of property. So that would be stayed. Also, actions relating to domestic violence, and lastly, the one that I have on the slides, it's relating to withholding, suspension, or restriction of a driver's license, professional or other occupational license, or recreational license. Those are left to the policing authority to deal with, and the bankruptcy will not have any impact on that. So a lot of times, I've had people come to me and say, okay, I filed bankruptcy, can I automatically get my license back? The answer is no. If your license is suspended, it's still suspended. It doesn't automatically go back in place, but there is a process and procedure to get it back in place, especially if it's only dealing with payment of a certain amount of money. Then there are certain ways to go about doing that. But if your driver's license is restricted or suspended, it's still suspended even if you file bankruptcy. As I said, it's an injunction, but it doesn't last forever. So the automatic stay, when you talk about when it terminates, with regard to actions against property of the estate, that terminates once the property is no longer property of the estate. And you might say, well, how does that happen? When does something is no longer property of the estate? One situation in which that could occur is in a Chapter 7 case. If there is a trustee that's appointed, they review the assets that are listed, and there could be some piece of property that's owned by the debtor, but it has very minimal value, and it would cost more to administer that property than it would be to just abandon it. So in those situations, what the trustee will do is the trustee will abandon that particular property. So once it's abandoned, the automatic stay would no longer apply. Or if there's situations in which there's property that has substantial liens on it, a trustee may abandon that property as well, and then it would no longer be property of the estate, and the automatic stay would not apply. But assuming it's not dealing with the property of the estate, so for example, if it's some type of litigation that was occurring in which it wasn't resolved in the bankruptcy process, then the stay would apply until the earliest of when the case is closed, the case is dismissed, or when a discharge is granted or denied. So that's kind of when the bankruptcy automatic stay would terminate. I'm going to talk a little bit about the claims process now, and when I say claims process, I'm referring to how do I get paid if someone files a bankruptcy case? What do I need to do, or what should I advise my client to do in order to let the bankruptcy court know I have a claim against that debtor, and to the extent there's money available, I want to get paid, or I want to receive a distribution. So what will happen is normally shortly after a case is filed, when the notice of the bankruptcy is sent to the debtor's creditors, and normally the debtor is the one that lists its creditors, and it lists their address so that they can get notices in the case. There will be a notice of bankruptcy, and in that notice, there's typically a claims bar date that will be set. Sometimes in no asset type cases that are filed initially, there might not be a claims bar date for companies, but other times they'll list the date. And typically the date is, I believe it's 60 days or so after approximately the meeting of creditors, the 341 meeting of creditors that we briefly discussed before. And that's the deadline to file the claim. There's a separate deadline for governmental entities, but unless you're representing a governmental entity, then you are the earlier deadline to file the proof of claim. A proof of claim, it's deemed allowed once it's filed, unless there is a valid objection that's filed to the claim. And once the objection is filed, if the debtor in possession or the trustee and the creditor can't resolve the claim, then essentially what that does is it creates a contested matter for the bankruptcy court. And then the court will get involved, and then there will be an adjudication within the court of whether or not the claim is valid or not. Because in order to receive a distribution in a case, you need to have a valid claim. That's kind of the initial step getting there, is to make sure you have a valid claim. But even if you have a valid claim, there's no guarantee of a distribution. Because in a Chapter 7 case, there's only distributions to the extent there's assets available. And in a Chapter 11 case and a Chapter 13 case, there's plans that are set forth that detail what the distributions are to creditors. And the one thing that's important to know is not all claims are treated equally. In the Bankruptcy Code, there's a priority scheme in which claims are paid, and so it's detailed. There's administrative claims, which are the costs involved with administering the bankruptcy case. There's secured claims, which are typically claims in which people have liens on property, certain specific property of the debtor. There's priority unsecured claims, which are paid above regular, we call them general unsecured claims. So the Bankruptcy Code itself details the process for payment and the distribution of the debtor's proceeds in a Chapter 7 case. In a Chapter 11 case and a Chapter 13, it has the framework, but that can be adjusted by the parties depending on whether and what they agree to. The next thing we'll talk about is the discharge. What a discharge does is it's a permanent injunction barring the collection of pre-petition claims against the debtor. And when we talk about pre-petition claims, those are claims that existed prior to the petition date. So this is another situation in which that petition date is very important. And it's important in situations where if there existed a claim prior to that date, it can be discharged. But if someone commits a tort or something or breaches a contract after the petition date, then that's typically not subject to the discharge, and the other party can continue and try and collect on that post-petition claim. There are certain exceptions to the discharge, which are automatic, and when I say automatic, that means that there's not the requirement of any filings in the bankruptcy court to accept these from discharge. And those typically happen with certain taxes, domestic support obligations, and student loans. One of the big questions and one of the issues that a lot of people are facing is when they consider bankruptcy is, well, what happens to my student loans? Because if I file, I have, $20,000, $50,000, $100,000 in student loans, then it says, is there any way that these get discharged? I mean, the answer is they can get discharged, but that's the exception. You typically have to demonstrate some undue hardship, and there's very, very, very few instances in which people are able to meet the standard for the discharge of a student loan. But in order to do that, the debtor is required to seek affirmative relief in the bankruptcy court seeking to discharge that, because the default rule is that the student loans are non-dischargeable. And so when you hear that word non-dischargeable, that relates to a debt that is not discharged from the bankruptcy case. Other exceptions will require the filing of an adversary proceeding. And again, the adversary proceeding is the litigation. It's a litigation matter within the bankruptcy case itself. But you file a complaint, and it proceeds from that point forward as typical litigation as if you were in, state court or federal district court. And that the other exceptions deal with if someone obtained a debt by fraud, defalcation, false financial statement, and willful injury. If the creditor can prove one of these exceptions, then that debt will not be discharged either, meaning it will remain a liability of the debtor after they do receive their discharge for other debts. In certain instances, a debtor can have their entire discharge denied. This comes up in certain instances, and essentially this defeats the whole purpose of filing a bankruptcy case, especially for an individual, because individuals file because they want a discharge of all of their pre-petition debts. If they weren't going to get that discharge, then 99% of the people probably wouldn't have filed the bankruptcy in the first instance unless they were doing it for some other reason. And what happens is under 11 U.S.C. 727, a debtor can have their entire discharge denied, and sometimes that has to do with making false statements in the bankruptcy case, making false statements in the bankruptcy petition, failing to disclose the disposal of assets, and those are situations in which the entire discharge could be denied. And as I mentioned earlier, corporate debtors do not receive a discharge, so the discharge only applies to individuals. Sometimes people, their only experience with bankruptcy is in the litigation context or in receiving a demand letter from a bankruptcy trustee or a debtor in possession. And that demand letter sometimes says, you are the recipient of a preference or you are the recipient of a fraudulent transfer. You must return that money to the bankruptcy estate. And a lot of people, when they receive those or their client receives those, they say, what is this? I don't know what's going on. I didn't know this company was going to file bankruptcy. I dealt with them at arm's length. Why am I receiving this letter that's telling me that I did something wrong and is requiring a repayment? The first one I'll talk about are the preferences. So the preferences are created by the Bankruptcy Code, and they only exist in the bankruptcy process itself. And the purpose of a preference is to avoid a debtor just prior to filing bankruptcy from preferring certain creditors over others. While the goal of the bankruptcy process is to give the debtor a fresh start and to eliminate their debts by giving them a discharge, another goal of it is fair distribution among the debtor's creditors. So the preferences typically happen within 90 days of the bankruptcy filing, but it would be a one-year period for insiders of the debtors, typically principals or higher-ups, sometimes affiliates, a spouse, children can also be insiders. And so it talks about unfair distribution, and the bankruptcy trustee or the debtor in possession will attempt to bring that money back into the estate to satisfy the claims of all creditors. Because if one creditor received $1,000 the day before the bankruptcy case was filed, the other creditors to them believe it would be unfair and say, well, I too should have received a distribution. They shouldn't have received the $1,000. So if there were four creditors, then the $1,000 would come back into the bankruptcy estate, and they would each receive $250 as opposed to the one receiving the $1,000 prior to the filing. Obviously, that's a very simplified example, but it just shows you the preference in preferring one creditor and then how the bankruptcy process tries to make it equitable to all the creditors. So although nobody received, it'll be a pro rata distribution. Although nobody's going to receive their full amount, they'll each share in that $1,000. In the slides, I outlined the elements of a fraudulent or of a preference, and I'll just read through that pretty quickly. But it's a transfer of an interest in the debtor's property, so that the property must be the debtor's that was transferred, on account of an antecedent debt made within the preference period, and again, that's 90 days for general creditors, 1 year for insiders, while the debtor was insolvent, to or for the benefit of the creditor that permits the creditor to receive more than it would under a Chapter 7 had the transfer not been made. So if the debtor or in possession or trustee can satisfy those elements, then the money will come back into the estate for distribution to the creditor body as a whole. There are certain affirmative defenses. One of those is, it's called the new value or substantially contemporaneous exchange. That's essentially a payment at the exact same time as that you receive the goods. There's an ordinary course of business defense, meaning that the payment was made pursuant to the customary terms and how the debtor and creditor operated prior to the bankruptcy filing. So it was just consistent. For example, if the debtor paid the creditor on every invoice that it received every 15 days, and the payments that were filed within the 90 days were consistent with the payment in 15 days from receipt of the invoice, then that would be a defense, because that would be in the ordinary course of business between those parties, and it wasn't a preference because they weren't preferring them, they were continuing to pay them as they had done in the past. But sometimes that can be a very nuanced analysis, especially for parties that have had a very long relationship, and you get into problems sometimes when the payments aren't regular. There's also certain safe harbor provisions for financial institutions, and then also purchase money security instances. The other situation in which the debtor in possession or trustee will attempt to bring assets into the estate is through proceeding with fraudulent transfers. This is when people hear the word, I don't know if people have ever heard it, clawback. Essentially what that's attempting to do is undo a pre-petition transfer to a party and to bring that money back into the debtor's estate. There is a statutory fraudulent transfer under the Bankruptcy Code, and there's also a provision within the Bankruptcy Code that allows the debtor in possession or the trustee to proceed under state law. That becomes beneficial in certain instances because under the Bankruptcy Code, there's only a 2-year look-back period, and the period starts from the petition date and goes backward 2 years. Whereas under some state laws, it can be, like in Florida, 4 years, and I believe New York is 6 years. So there's a longer period if you use a state law in which you can go back to try and recover certain transfers of the debtor's property that was made. There's 2 types of fraudulent transfers. There's constructively fraudulent transfers, and then there's actual fraudulent transfers. The typical constructive fraudulent transfer is someone purchases, the debtor sells goods, the debtor has a good that typically sells for $100,000, but in this instance, the debtor sold it for $50,000 without any justification for doing so. If the debtor was insolvent, meaning its assets were less than its liabilities at that particular time, or it wasn't paying its debts as they came due, and there's no justification for that reduction in the amount that was paid, then that's the type of claim which would be a constructively fraudulent transfer, meaning the debtor didn't receive reasonably equivalent value, and the trustee or debtor in possession would attempt to recover that asset that was sold or the value of that asset to bring it into the estate for recovery for all creditors. The other type is actual fraud, and this is where it actually requires intent. And so there would be an intent to defraud a particular creditor or the creditors as a whole. And they're typically what we call badges of fraud, because in most instances, you'll never get a debtor to say, yes, I meant to defraud this creditor, and that's why I made this transfer. So what the courts do is they look at badges of fraud. So they'll look at, okay, was there value given for the transfer? Was the transfer to an insider? Because that's very important, because a lot of times before people file bankruptcy, they'll attempt to transfer assets to relatives, or if it's in the case of a company, they'll transfer assets to an affiliate of theirs, just to try and keep them out of the bankruptcy estate, so they won't be assets for everybody, the creditors as a whole. Other things they'll look at too are when was the transfer made in relation to the bankruptcy filing, whether the debtor transferred it on paper, but in actuality retained possession and control of the asset. They'll look at the solvency or insolvency of the debtor. And really, it's a holistic approach where you just look at all the facts together and say, okay, was this an above-board transfer or was it one that we should investigate? And those are the two types of litigation that a lot of people will come into contact with, and those are typically the clawback litigation that occurs. But those were very, a general overview. They can be very nuanced during the process, but like I said, the goal here is to just get you familiar with, a fraudulent transfer, being able to understand, was it constructive fraudulent transfer, was it an actual fraudulent transfer? And the one thing that I'll say that's very important is, if you're dealing with a client who receives something regarding a fraudulent transfer, in the case of an actual fraudulent transfer, a lot of times, the intent that they look at, it's the intent of the debtor who was transferring it. It's not the recipient. So your client could have done absolutely nothing wrong. They thought they just negotiated a great deal or something else, but it's the intent of the debtor when making the transfer. The last topic that we'll quickly cover, deals with the plan confirmation process. So this would occur, and when I talk about this, it's really in the Chapter 11 context, which most of the time happens with businesses. So after the petition is filed, there's typically some type of discussion and negotiation between the debtor and the various creditors and equity holders within the bankruptcy case. After some negotiations are had, what the debtor will do is they'll set forth a disclosure statement and their proposed plan of reorganization. The purpose of the disclosure statement is to describe in detail the plan itself, the plan of reorganization. So the disclosure statement will a lot of times be a lot more detailed than the plan, and will kind of give the framework as to how what's stated in the plan will actually come to fruition and actually work. So the debtor will file the disclosure statement and attach a copy of the plan, and then it's up to the debtor to convince the court that the disclosure statement and the plan contain adequate information. And adequate information means that it contains sufficient information in order for the typical creditor within that case to make an informed decision of whether or not they want to vote to accept or reject the plan. So assuming that it meets that standard, then the court will tell the debtor, you can go ahead, you can distribute the plan for voting by all the interested parties, and then the plan will be sent out with the disclosure statement again, and there will be a ballot that's attached to the plan. And the ballot will say, you are a creditor in this category. Do you accept your treatment or do you reject your treatment? Once all of those ballots are received back, and there's typically a deadline that will be on the ballot in which you have to return the ballot, the debtor will come back to the bankruptcy court for what's called a confirmation hearing. They'll go before the court and say, Judge, look, we have all these ballots. And obviously, if everybody accepts the plan, great. That makes the confirmation process a lot easier. But there's other requirements other than just purely voting that are required to be met before a plan will be confirmed by the bankruptcy court. And that section where you find all of those is in 1129 of the Bankruptcy Code. But assuming the plan is confirmed, what the plan is it's a contract. So the plan creates new debtor-creditor relationships with all of the parties that were involved. So if a contract existed prior to the bankruptcy being filed, you need to look to the plan to see what the terms of the contract are after confirmation. In certain situations, they may be the same, but in other situations, the terms may have been adjusted and such that you need to really look to the plan to see what the new relationships are. So if you ever have a client that says, oh, this entity filed bankruptcy, it was a Chapter 11, they had a plan that was confirmed, I'm not sure if I was supposed to receive a distribution, I'm not sure what my relationship is with the debtor now going forward. A lot of times the place to start would be the plan and also the confirmation order, so the order confirming the plan to see if it modified the plan in any respect, to see what the new relationship is, and also the plan will detail what the distribution is supposed to be to all the creditors and the other interested parties. There are situations in some bankruptcy cases in which the debtor, who has an exclusive period in which to file a plan, either doesn't do it or other parties want to file a competing plan because they think they can do a better plan than what the debtor is doing. And so that's a situation that does arise sometimes. And that plan also needs to meet the requirements of 1129 of the Bankruptcy Code. So the plan confirmation process, although we fit it on one slide, it's a very detailed process, and sometimes it can take, 6 months, it could take a year and a half. So it really depends on the facts of a particular case and what the debtor is attempting to do. So I believe that I've covered the topics that I wanted to cover, Jesse, and I didn't know if you wanted to open it up if we had time for questions or...
We did have one question, which was, how is secured debt handled in a Chapter 7 bankruptcy?
Well, secured debt in a Chapter 7 bankruptcy, it can be handled in a couple different ways. And it really depends on whether there is value over and above the secured claim. And what I mean by that is, say you have a piece of real property and the creditors owed $80,000. The property is valued at $150,000. So in a situation like that, what a bankruptcy trustee would attempt to do is liquidate that asset, meaning do some type of sale of the asset, and then pay off the $80,000 claim, and the remaining $70,000 would be left to be distributed to the other creditors in the bankruptcy case. So the secured creditor would get the value of their claim, and the overage would go to pay claims of other creditors. Now, if you do represent a secured creditor, a lot of times one of the things you can do is there are situations when you can get your attorney's fees included in the amount you're owed, so that would be an additional amount that would need to be covered. In situations in which the value is less than the secured claim, or it's the property's underwater, a lot of times that's when the secured creditor will, if they want it done quickly, they'll seek a motion with the court for stay relief so that they can proceed, if there was a lawsuit pending prior to the case, to sell that asset, or they'll wait till the case is closed or it's abandoned or the debtor gets their discharge. So that's typically how secured claims are dealt with. If the secured creditor, if they're owed $80,000 and the property is only worth $60,000, then they'll also be able to file an unsecured claim for the remaining $20,000.
We are just about out of time. If there are other questions, can participants email you? And if so, do you want to provide your email address?
Yeah, absolutely. If anybody has any questions, my email address is on the first page of the slides, but for people who aren't looking at the slides, it's Vincent, VINCENT, Alexander, ALEXANDER, at Lewis Brisbois, LEWISBRISBOIS.com.
Well, thank you, Vincent. That was an excellent presentation. So again, my name is Jesse Butler. I represent the 12th Judicial Circuit on the Florida Bar Young Lawyers Division Board of Governors, and the WILD advocates, educates, and serves all young lawyers in Florida, including producing the basic CLEs that you're required to take within your first 3 years. If you want more information about what the WILD does, feel free to contact me, Jesse Butler, at jbutler@dglawyers.com, or visit the WILD website, flawild.org. Thank you again, Vincent, for your presentation today. Everyone who attended today's program program will receive a follow-up email enclosing the CLE course code, which qualifies for 1 general CLE credit that should arrive within the next 48 hours. To earn your CLE credits, you must enter the CLE course code on your member profile on the Florida Bar website located at www.floridabar.org. And if you have not noticed already, when you log in on the left-hand side, there should be a new link to the Legal Accelerator website, which is a one-stop hub for young lawyers to get answers to many common questions that they will encounter as they transition to the practice of law. This was a feature recently launched by the YLD, and it's kind of a Google-like website where you can search for substantive legal questions, professional development, or other issues that pertain to young lawyers. For more information about the Florida Bar Young Lawyers Division's Technology Committee, including additional free on-demand technology webinars, please visit www.flaYLD.org/technology. On behalf of the Florida Bar Young Lawyers Division Board of Governors, we thank everyone for attending today's program and look forward to seeing you all at a future technology CLE webinar. Thank you. Okay.